A pleasant afternoon. Good day to everyone. Again, we are now on the part 8 of our presentations on the series of criminal law, book 1. So once again, this is Dr. Ariel D. Manlusok, the director of the ADM RC. Now our topic is about absolutory cause, which is another circumstances that affects criminal liability. Although it cannot be found in one article, it is spread out in the different articles of the book 1 and the book 2 of the revised penal code. Now let's start. Okay, what is absolutory cause? Absolutory causes are those where the act committed is a crime, but for reasons of public policy, take note, public policy and sentiment, there is no penalty imposed. So as you can see, the difference between absolutory cause and exempting circumstances is in exempting circumstances, there is no penalty by reason of public policy and sentiments. While in exempting circumstances, although there is a crime, the person is not criminally liable because there is a lacking element in the commission of a crime that is normally attributed to the offender himself. Okay, so what are these absolutory causes? We have enumerated 7 or 8, although the usual being discussed are 5 only. And what are they? The number 1 is spontaneous desistance under Article 6. Now, this is actually discussed in the previous discussion of the book 1. Okay, Article 6 is discussing about the stages of crime, the attempted, frustrated, and consummated. Now, spontaneous desistance is only applicable at the attempted stage. So what does it mean? Once the offender is about to commence the execution of a felony directly by means of an overt act, but before he actually executed the overt act, he was suddenly have a change of mind. What does it mean? He decided not to continue perpetrating the crime that he decided to commit. Okay, so that is actually the concept of spontaneous desistance. That before any crime was actually being committed, the perpetrator decided to not continue with his plan. So meaning, at the last moment, he made a right decision to do what is right and avoid what is evil. And as a consequence, the law exempt him from the fact that he made a right choice. Although at the beginning, there is the criminal intention to commit a felony. The second one is in relation to the concept of what we called, there you are, accessories. An accessories is the one who gives aid, no? The one who profited, the one who harbors, the one who assists, the one who conceal, okay, the perpetrators after the crime was actually being committed. Now take note carefully that accessory only participates after the crime was already been committed. Okay, although there are 3 kinds of accessories as mentioned under Article 19, which we will discuss that in another video presentation. Now, when we discuss about persons who are criminally liable, no, yung principal, accomplice, and accessory, we will have a separate video presentation for that purposes. Okay, so here, this is actually found under Article 20, which provides that if the accessory is a relative of the principal, like for example, a son, a daughter, okay, a niece, a nephew, or the ascendants or descendants of the principal, but most likely for those who are descendants, no, because of the moral ascendancy. If the principal requested the relative to assist him, for example, in covering up the crime scene, like for example, destroying the pieces of evidence, okay, cleaning up the crime scene, or burying the dead body, okay, the principal here is liable for the crime that he has committed, but the accessory who is a relative cannot be held liable as accessory for the crime committed by the principal. Although this provision of the revised penal code is subject to exemptions. Why? Because pursuant to Article 20, an accessory who is a relative who is benefited, okay, under Article 19, Paragraph 1, is liable as an accessory. So take note, an accessory who is benefited or who profited from the result of a crime, even if he is a relative of the principal, is criminally liable under the law. Okay, another limitations here is that in under the special law, which is the Presidential Decree 1612, the anti-fencing law, once the accessory is performing an act in connection to the crime of robbery or theft, no, yung crimes against property, robbery and theft, the one who assists or who profits from it can be held liable not under the revised penal code but under the special law. Okay, and what is that? Fencing. No? Why? Because fencing is the act of buying, selling, profiting, or benefiting from the fruits of the crime of theft or robbery. So, the accessory might be exempted as accessory for theft or robbery, but he is not exempted as principal for the crime of anti-fencing, although he is a relative of the principal. Okay? Another limitation here is also under the special law, the PD 1829, the law on obstruction of justice. Okay, a good example of that is what happened in the case of Ivler, where the mother, okay, conceal the son Ivler in their house. So the NBI barges in and they discovered that Ivler was there, and there was even an exchange of fire. So in that case, the mother can be charged for obstruction of justice, although he is a relative of the principal. Okay, so generally under the revised penal code, a relative who is an accessory is not criminally liable as accessory, provided he did not profited or assist to profit from the fruits of the crime. Okay, what about the third one? Okay, this is an example, by the way. X killed Y. After killing Y, X requested his son, B, to help him bury the cadaver of Y. Okay, sorry for the error. That is to help him bury the cadaver of Y. B is not liable as accessory to the crime of homicide because B is the son of X, who is the principal. But provided, as I said, note, B did not profit or assist to profit from the crime. But nonetheless, he can be dealt with some special law, such as PD 1829, which is the law on obstruction of justice. Another example of absolutory cause, okay, is in cases provided by Article 247 of the revised penal code. We know that there are two scenarios here. No, one is with regard to spouses, and the second is with regard to the parents in relation to their daughter who is minor. Okay, but under the Article 247, there is a penalty provided. But that penalty of destierro is only provided when the spouse or the parents killed, okay, killed the parties or the person involved in the sexual intercourse, or he or she inflicted a serious physical injury. So that is not an absolutory cause. What is absolutory cause here is if what is inflicted by the parents, okay, or by the spouse is only a slight physical injury. In that case, there is no penalty provided by the law. Again, just to clarify, so this is the case of the so-called death and serious physical injury under exemptional circumstances. And as I said, if the result of the assault, because the spouse or the parents were surprised that the other spouse or the daughter is having sexual intercourse with another person, is death or serious physical injury, there is a penalty of dischero. But if what is inflicted is only slight physical injury, there is no penalty imposed by the law. That is the absolutory cause under Article 247. Now let's go to number 4, circumstance. Okay. The fourth circumstances under absolutory cause is in the case of relatives again. But this time, relatives are exempted from criminal liability for the crimes of theft, swindling, otherwise known as estafa, and malicious mischief. Okay? By reason of relationship between the offender and the offended party as stated under the last article of Title 10 Crimes Against Property, Article 332. Okay. Now take note, this pertains to crimes against property. Relatives who are included in the defense of relatives, which we discuss in justifying circumstances, are entitled for this kind of absolutory cause. But take note what crimes are covered. There are only 3 crimes that are applicable for absolutory cause due to relationship between the offender and the offended party, and they are what we call the MET. That's the acronym for easy recall. MET. M stands for malicious mischief, E stands for estafa, and the third T stands for the theft. So only these 3 kinds of crimes against person exempts a person by reason of relationship to the offended party. It does not include robbery. Take note. In robbery, even if the offender and the offended parties are relatives, they are not covered by absolutory cause. The relatives who commit the crime of robbery is liable, but this may take form of a so-called mitigating circumstances because relatives or relationship is one of the 3 absolutory causes, which can either be aggravating or mitigating. But in the case of crimes against property, relationship is a mitigating circumstances. No, compared to crimes against person, the relationship between the offender and the offended party is an aggravating circumstances. Okay, and the fifth one is the so-called instigation. This instigation is considered absolutory cause. Why? Because this is prohibited or this is not legally acceptable in our police parlance. So what is this instigation? Instigation happens when the officer, no, the police officer or the warrant officer, the one who will make an arrest rather, is the one who actually induced the would-be offender to commit the crime. Then after, he arrested the same person, and as a result, that person cannot be held liable. For what reason? For the reason that this is not an entrapment. This is an instigation. Or in short or simple word, it is an inducement. The police officer is the one who induced the will-be offender, and the same officer arrested the one that he induced. So in that case, the one that was induced will not be criminally liable. It is the officer that will be dealt with because of this irregularity. Take note, what the law allows in the police operation is the so-called entrapment. And what is entrapment? Entrapment are the application of the various ways or means in order to capture those who commits violation of law in the act of executing a crime. That is the concept of entrapment, wherein most of the time the law enforcers will come up with the so-called bypass operation, wherein they have to execute the actual operation by barging in and by arresting the persons in the act of committing a crime. Okay, as distinguished from raid is only describing that act of those enforcers surprisingly enter or intrude a premise. So a raid can be just a part of a bigger operation called bypass operation. And bypass operation is an operation conducted for purposes of ensuring an entrapment. Okay, so that is the one legally acceptable. The last one that we have, uh, in addition rather, is the so-called under the provision of trespass to dwelling. We know that a civilian who enters the dwelling place of another without the latter's consent is liable for trespass to dwelling. But Article 280 provides for three exemptions where trespass to dwelling is not punishable. And what are they? A. For purposes of preventing serious harm to oneself, the occupants, or a third person. For example, no, yung kapitbahay mo, your neighbor, jumped to your what property because he was being chased by his wife with a bolo. Can you charge that neighbors of yours with trespass to dwelling? No. By reason of public policy and sentiment, he is just merely saving himself from the possible harm, so he is not criminally liable for trespass to dwelling. Or, for example, your neighbor try to enter your premise because they want to protect you. So you cannot charge them definitely for trespass to dwelling because they are acting in good faith. Okay, letter B, for purposes of rendering some service to humanity or injustice. Like for example, in cases of fire, in cases of calamities, if other people intrudes to your premises for purposes of helping, assisting you, or protecting the occupants of the establishment, like what other civilians are doing, or even law enforcers or firemen, they cannot be charged of trespass to dwelling or even violation of domicile for the fact that they are intruding your premises for purposes of service to humanity and justice. Okay? And the last is if we enter places that are open for public. Now, we know that there are what called cafeteria, tavern, inns, no restaurants. These places can be intrude by anyone as long as the premises is already open for the public. That's why it is a requirement that if a place is designed for public, there must be a signage of open or closed. Because if the premise is closed and you enter, you can still be charged for trespass to dwelling for that purpose. In addition to that, I also added two more articles which are provided under the revise. One is accessory, who are exempted for what? To light felony. Because under Article 16 of the Book 1, once a felony is light felony, only the accomplice and the principal are criminally liable. The accessory is not criminally liable for the reason that okay, there is no more penalty that can be imposed to the accessory in a light felony. No, applying the principles enunciated under Article 50 to 57 of the Book 1. The same is true under Article 9 of the revised penal code or article 9 or 77 that light felony are punishable only when it is consummated. So if the light felony is only attempted or frustrated, the person is not criminally liable. Why? Because there is no penalty imposed by the law. Exception, meron po dalawang exemption in case of crimes against person and crimes against property. Okay? So those are the absolutory causes. So thank you and God bless. See you on the part 9 of this Criminal Law Book 1 series. That will be the mitigating circumstances to be followed by aggravating and alternative circumstances. The moment we finish the 3 remaining circumstances, we will jump to the so-called principal, accomplice, and accessories, which are also a favorite in the board examination for criminology. So thank you and see you to the next presentation. God bless.